Everyone, I'm S. Kirti Rakshya, doing my third year at Savita School of Law, and today we are going to look upon the concept of trademark very briefly. Trademark in India is governed by a legislation known as Indian Trademark Act 1999. It has 13 chapters and 159 sections. Our trademark in India is governed by a legislation known as Indian Trademark Act 1999. It has 13 chapters and 159 sections. Out of the Act, Section 21ZB defines trademark. It has three categories to identify a mark as a trademark. The mark should be graphically represented and it should be capable of distinguishing the goods and services of one person from the other, and it should include shape of goods, packaging and the combination of colors. So we have types of trademark. In types of trademark, we have two groups called as the conventional trademark and non-conventional trademark. In conventional trademark, we have three types, that is certification mark. For example, FSSAI and ISI are called as certification mark, collective mark and service mark. And in non-conventional trademark, color trademark, sound trademark, packaging trademark, hologram and shape of goods. An example for color and packaging trademark will be the purple colored packaging in dairy milk products. And regarding the sound trademark, an example would be the introduction sound of a Tom and Jerry series. There is another category known as the well-known marks, which have acquired the trademark because they are very well known in the society. And there are certain features of a mark, of a trademark. The trademark has to be distinct in nature, that is, it should differentiate from the other trademarks. It has to be short and appealing. So what are the advantages of having a registered trademark? The registered trademark will protect the goodwill of a company and the brand name of a company. It gives the status of branded goods to the products that is going to be sold with this trademark. So in society, we have a belief that all the branded goods are of good quality. So whenever a product is branded as a good quality product, then the value of that particular product will be high, thereby increasing the economic value of a company. So trademark has a very important role in the economic status of a company. And the last advantage is it serves as a proof and protection in any case of suit for infringement in the court. So regarding the registration of trademark, we have refusal of registration of a trademark, where a registration of a trademark can be refused on two grounds, two groups of grounds. They are absolute ground and relative ground. Under absolute ground, if the mark is devoid of any distinctive character, which is not a feature of itself, and if it indicates the qualities, descriptive character of a product, or if it has become customary in the current language. So these are the 3 points to be remembered with regard to a trademark in absolute grounds. And in relative grounds, if the mark is deceptive or confusing in nature, if the mark hurts the religious sentiments, or if the mark is obscene or scandalous, or if the mark is prohibited under Emblems and Names Prevention of Improper Use Act 1990. So under all these 9 categories, the trademark can be refused for registration. So there is another concept called as concept of distinctiveness, which tells that one trademark has to be distinct from the other at the time for period of time. That is, at the time of registration, at the time of opposition for registration, infringement of another, and in case of passing of action. This is the concept of distinctiveness. So regarding to the term of protection, Section 25 Clause 1 of the Act tells that the trademark can be protected for 10 years from the date of the registration, and this protection can be extended for another term upon renewal, and the renewal can be taken place any number of times, and how many ever times the trademark is being renewed, 10 years protection will be granted. We have looked upon the registration and refusal of a trademark, what is a trademark, types of trademark and all. So we have to see what is an infringement of trademark and its remedies. Whenever a trademark is being copied by the other company, or if it is being used by the other company without the permission of the owner of the trademark, then that trademark is said to be infringed. And the owner of the trademark has certain remedies. The first remedy is he can file a suit for infringement and claim for interim injunction and permanent injunction. Interim injunction is to restrain the offender from using the trademark in the future, and permanent injunction is the same as interim injunction but for a permanent period of time. And the last remedy is the owner can claim damages and compensation for the use of trademark without his permission. So this is regarding the infringement and its remedies. So we have last 2 topics under trademark. They are doctrine of honest concurrent user, assignment of trademark and license of trademark. Under doctrine of honest concurrent user, it says that a person can adopt and use the mark by another person with the permission of the trademark holder, provided he has to prove his honesty and the motive behind his use. So this is a doctrine of honest concurrent user. While the concept of assignment of trademark and license of trademark is the owner of the trademark can transfer his trademark like an asset to another person for a particular purpose and for a particular period of time. This is called as assignment and licensing, where in assignment the royalty for this trademark can be negotiable between the parties, while in licensing it is to be decided by the board. So this is the concept about trademark and its related concept very briefly. And the link for the notes and the PPTs and poster is given in the description below. Thank you.